How did this lawyer convince this judge
right there, and it says security instrument all over this deed of trust no less than about 30 times, I believe. This is a security, and this is why they will not ever produce the original.
I mean, after the time, I remember this time you got Thomas Dore under oath, and he pretty much said that he didn't have any first-hand knowledge of anything.
That's correct.
Then after that, you've never really been in court.
It's been about 3 years. August 11th, 2010, I believe, was the date of the hearing. It's been almost 3 years. This is April 30th, 2013, so almost 3 years.
Who is that lawyer right there? And what did he do with that bag right there that impugns the integrity of the Baltimore District Court? Simple. He brought a courtesy copy of a motion to dismiss on behalf of M&T Bank to Mickey Norman, who then turned around and completely lied about the intent, the focus, the purpose, the direction of Emergency Rule 14-2071 that was propagated in part by that man, of course, Judge of the Year. So, this all happens at a time when you have the highest foreclosure rate in the country in Maryland. This all happens at a time when the research of law clerks like Jose Portillo and me, and the homeowner in this case, are all designed to address this serious problem. And the problem is so serious that there are thousands of tainted deeds of trust throughout the state, and it's an epidemic problem. People are looking up, and cases are being thrown out because of these problems, as you can see here. In any event, these situations are serious, and Judge Norman, who I believe has ties to foreclosure mill attorney Thomas Dore's alma mater, couldn't care less about these issues. It flies in the face of Judge Wilner and the committee, and you'll see why momentarily.
Counsel, how many times has Mr. Dore been sanctioned?
All right, great. You're keeping up. Now let's return to Attorney Lee. The reason why he hand-delivered that courtesy copy of the motion to dismiss to Judge Norman is because he didn't want to turn it over to Judge King, because Judge King is the second judge to have reprimanded Dore for false documents. And of course, false documents goes to the core of 14207.1. Got it? There's the other judge there, Judge Karam. See? So no wonder he doesn't want to talk to me at all. But I'm here, and I'm going to be addressing these issues. Now, here's the committee. We're going to get a copy of this video, and let's see where it goes from here. We've seen Junior Judge Norman completely disrespect Senior Judge Wilner, Judge of the Year. All right, so if he's going to do that, he'll stoop to no level to protect M&T Bank and these lawyers. So what we need to know now is about this judge, Robert Cahill, and where this fits in. Judge Cahill issued an order dismissing a counterclaim of declaratory judgment filed by the homeowners because there was a portion of the case that was on appeal. Therefore, the trial court lacked jurisdiction. Well, what the court and opposing counsel did throughout the proceedings, while the court yelled and berated Mr. Wetzelberger, what they did was they assumed that the second order issued by Judge Cahill that day was ruling. And the second order said that the dismissal was with prejudice, as opposed to simply being for lack of subject matter jurisdiction. But you can't assume that negative inference. You have to assume, for example, that the order just dismissing it for the jurisdictional issue is the final order, and that it's corrective in nature. You understand? But no, that's not the way that Judge Norman's going to do it, because he's, you know what he's doing.
Non-agency means it's not Freddie or Fannie or Ginny. I want to know what this means, D5B31. If there's a true copy of the original, what is that code? And what is this TREAS? I presume it means Treasury, 3107.
Looks like it went to the Treasury.
It looks like it went to the Treasury on March of '07. And if you look at the Securities Exchange Manual, 1934, it says a deed of trust in the hands of a managerial third party is a security. And if you look down here, it says security instrument right there. And it says security instrument all over this deed of trust no less than about 30 times, I believe. This is a security, and this is why they will not ever produce the original, because this has been pledged, hypothecated, or both, as a security, and they will not give it back.
Another thing to remember is my notice of media coverage. This is the second or third one. I send them certified mail. They have them, but then I get there and there's nothing in the file. But yet, even while I'm in court during the hearing, they're looking me up online. And then after that, the law firm's looking me up. Everybody's looking. Ladies and gentlemen, I was a former state attorney, title insurance producer. I've worked in related areas for years, and this is crazy. You can't just flip the burden of proof in a case like this by saying that the homeowner didn't show affirmative proof they didn't sign something. No, the burden, let's acknowledge it, of course, the burden is always on the moving party. This is totally unconstitutional. What's going on here today at the courthouse is more injustice. It's the stock and trade. It's as embedded in the mortar of this building as it is across all the other similar courthouses in America. And I don't know what Channel 11 News is doing here.
Nothing!
Okay, now, you're suing these people for declaratory judgment, correct? Because they had initially tried to foreclose on you?
Real simple, yeah, declaratory judgment, and that's the most basic way I can try to get some resolution, I think, because nobody wants to produce any proof of claim over the past 4 years, so...
And all you're looking for is a valid chain of title, right? A proof of claim.
Proof of claim in general. I mean, if I say to you, hey, you owe me 10 grand and $10,247.63, and I say prove it, you gotta prove it. It's pretty straightforward.